Ladies and gentlemen, welcome to the CIL eAcademy and this week's lecture by His Excellency Mahmoud Daifallah Hmoud on the immunity of state officials from foreign criminal jurisdiction, the interaction with diplomatic immunities. I now give you over to our co-director, Dr. Nilufer Oral.
Thank you very much. And again, welcome to all the participants of the eAcademy. I think we had a wonderful introduction to the very interesting topic of immunities, international law. And today we are so fortunate to have Ambassador Hmoud, who is currently the ambassador from the Hashemite Kingdom of Jordan and Singapore. And may I say also, he is also a fellow colleague of Patricia and mine from the International Law Commission. And I have to add here that Ambassador Hmoud has done such an excellent job in the commission that he was elected 3 times. So that's quite an accomplishment. But again, we have someone today lecturing who has diplomatic experience, but also experience before international courts, tribunals, the ICC. He'll be talking today about immunities from foreign jurisdiction. He was a deputy permanent representative for Jordan at the United Nations in New York. He was in charge of the Security Council. He's negotiated treaties, instruments. He has a wealth, an absolute wealth of experience. So again, not just bringing to you abstract knowledge, but actual experience. So I know he's going to give us a wonderful lecture today. So I won't take any more of your time. Ambassador Hmoud, the floor is yours. Thank you.
Thank you, Professor Olal, and thank you, Professor Galvao-Teles, for this. At the outset, I think the Center of International Law eAcademy has, I commend the Center for their efforts to promote international law in Singapore and Southeast Asia in general, and to raise awareness of legal topics and issues that play a pivotal role in international relations. And this eAcademy, E2020 Academy, is an important step in this direction. And I thank you for the invitation to speak. I'm going to speak today on a topic that raises several challenges to states in conducting interstate affairs and diplomatic relations. There's a wealth of practice, literature, and jurisprudence on the various issues involving diplomatic immunities and immunities of officials from foreign criminal jurisdiction. Yet the issue of immunity remains contentious and causes both tensions and instability in international relations. There have been many cases where the implementation of immunity towards diplomats and foreign officials have caused international incidents and either led to the severance of bilateral relations or threatened such relations. On the other hand, it is contended that immunities do preserve international peace and security, ensure equality of states, and avoid conflict. This has been recognized by the Vienna Conventions on diplomatic relations and the Vienna Convention on Consular relations, which refer in their preambles to such principles as sovereign equality and maintenance of peace and security, as well as to the goal of development of friendly relations among nations. Nonetheless, international law and international relations have developed over the past decades towards placing more emphasis on the protection of human rights, individual criminal responsibility, the need of accountability, and on closing the door on impunity. The creation of international courts and tribunals since Nuremberg and Tokyo actually attests to the importance that the international community attaches to the promotion of the rule of law and bringing the perpetrators of international crimes to justice. National courts have been exercising jurisdiction on the basis on cases involving the commission of the most serious crimes of concern to the international community, involving senior foreign officials with a mixed outcome. There have been scholarly writings and human rights advocacy efforts that purport to limit the avenues for impunity and bring those accused of committing international crimes to justice. Strong arguments are made why immunity should not bar prosecution of such individuals, even when they are senior officials and state leaders. Nevertheless, issues relating to immunity from foreign jurisdiction, criminal accountability, and sovereignty are not one-dimensional and involve various legal and political interests. International treaties and conventions play an important role in balancing such interests, including the Human Rights Conventions, treaties and instruments in establishing international criminal tribunals, the mutual legal assistance agreements, and conventions involving application of the principle of ordre judiciaire. This is just to name a few. International and regional jurisprudence also contribute to a better understanding of the various legal interests involved and to promoting the goals of protecting human rights and achieving criminal accountability while respecting the state's prerogatives and sovereign rights. It can be said, however, that there is no single set of general rules that can be applied in relation to the interaction between immunity and criminal accountability or criminal responsibility. There are also special regimes on immunity, such as the 1961 Vienna Convention on Diplomatic Relations and the 1960 Vienna Convention on the Council Relations, as well as special regimes on international accountability, such as the Rome Statute, or individual criminal responsibility, such as the Rome Statute for the ICC. There are divergent pronouncements from international tribunals and precedents that are followed by some tribunals, yet not others, depending on the tribunal. International regional treaty bodies do not provide uniform interpretation of the rules of immunities, and national courts and legislations apply different rules on immunity depending on the internal legal system of the state. As such, there is a need to identify general rules that preserve the balance of legal interest and at the same time provide minimum yet practical standards on the application regarding the immunity from foreign criminal jurisdiction. The work of the ILC on the topic is an effort towards this end. Over the past 13 years, the Commission has been debating the topic extensively and have received feedback from states and other actors regarding the content and scope of immunities, as well as their categorizations and limitations. While the debates have been extensive and there remains divergent views among members of the Commission on certain core issues, the ILC should be in a position to produce the first reading on the topic during the 72nd session of the Commission in 2021, hopefully. Considering the ongoing debate on the topic of immunity of state officials, I wish to proceed with identifying the core issues involved, taking into account the proximity of the underlying issues with concepts and treatments contained in the diplomatic law regime. The 1961 Vienna Convention on Diplomatic Relations is considered the cornerstone of diplomatic immunities regime. It provides, inter alia, a set of rules on privileges and immunities of diplomatic agents and other members of staff of diplomatic missions. The 1963 Convention on Consular Relations contains comparable rules vis-à-vis members of staff of consular missions. My comments will mainly deal with the former, while also referring to the latter for comparison purposes if necessary. The preamble of both conventions identified the purpose of immunities by stating that, I quote, "The purpose of immunities is not to benefit individuals, but to ensure the efficient performance of functions of the mission on representing states. This is the premise of immunity, which is not particular to diplomatic or consular agents, but underlies immunities extend to state officials from foreign criminal jurisdiction. The purpose is a crucial test that should provide answers to the various questions on content, scope, and limitations to immunity. In the arrest warrant case, the ICJ reiterated this purpose by stating that, I quote, in customary international law, the immunities according to a foreign minister are not granted for the personal benefit, but to ensure the effective performance of their functions on behalf of their respective states. This approach is also taken by the ILC under the topic Immunities of State Officials, and has been reflected in the commentaries of the Commission on the various articles provisionally adopted. It's important to note in this context that the ICJ has considered that immunity protects the foreign official against an act of authority of another state. This was mentioned in the arrest warrant case, as well as in the certain questions of mutual assistance case, where the court said that a determining factor of whether or not there has been an attack on immunity of the head of state lies in the subjection of the latter to a constraining act of authority. The court, therefore, did not consider the voluntary witness summons as a violation of immunity from foreign criminal jurisdiction. Thus, I quote, the effective performance of functions, unquote, and the hindrance of functions and the constraining acts of authority are all interrelated elements encompassing the purpose of immunity and ensuring a balance between the various legal interests involved. They are crucial to understanding how to implement immunity under the general rules and may provide guidance on the legality of measures taken by the foreign state that purports to exercise criminal jurisdiction. It should also assist in identifying the procedural regime or rules relating to immunity. A state has the right to exercise lawful criminal jurisdiction under international law to the extent that such exercises do not violate the immunity of foreign officials. If the act associated with such exercise does not entail authority or coercion over the official or hindering their performance, the performance of their functions on behalf of their states, then such exercise of jurisdiction should be considered lawful. Obviously, the implementation of this test depends on the circumstances of each case. But as a general rule, immunity is not violated by the exercise of the forum of its criminal jurisdiction in a manner that does not involve an act of constraint over the official or hindering their functions. This purpose test should apply across the board, whether the immunity is ratione personae or ratione materiae. I will note here that there appears another purpose reason, which is particular to immunity ratione personae, which is representing the state in international relations. This is found in the dicta of national and international courts and tribunals, including the ICJ, although the court never, at least explicitly, classified the two types of immunity as ratione personae and ratione materiae. The reference to representing states is also contained in the Vienna Convention on Diplomatic Relations, again, without explicit reference to the classification as ratione personae. I will deal with the distinction between the two types of immunity later, but the issue of representing states in international relations as underpinning immunity ratione personae has been subject to debate. In their joint separate opinions, which is widely quoted, Judges Higgins, Kuijmans, and Bergenthal endeavor to distinguish between immunities of heads of state and those of other officials by stating that the heads of states personify the sovereign state. However, they went on to acknowledge that foreign ministers, when acting on behalf of or representing their states, must enjoy I quote, full immunity, unquote, to allow them to perform their functions on behalf of their states. The opinion added that it is far less clear if foreign ministers enjoy such immunity during private travel. But in essence, the issue is more related to whether the position of a foreign minister is inherently interlinked to representation of the state, thus the being entitled to the enjoyment of immunity ratione personae. Here I would like to talk about, make reference to the IDI, the Institut de Droit International, why the IDI did not consider that a foreign minister is in a position inherently associated with immunity ratione personae and its 2001 Vancouver resolution. The ILC identified the Troika, that is the heads of state, heads of government, and foreign ministers, as covered by the regime of immunity ratione personae by virtue of their inherent representation of the state. On the types of immunity, in terms of doctrine, scholarly writings identified two types of immunities, as mentioned, for officials, state officials from foreign criminal jurisdiction, that is the immunity ratione personae and ratione materiae. This distinction in classification is useful for the purpose of providing general rules that are applicable when cases of immunity arise. But the essence is the content of the rules involved. As mentioned earlier, the International Court of Justice avoided doctrinal classification, but did identify relevant rules. The same may be said about the Vienna Convention of Diplomatic Relations and the Vienna Convention on Consular Relations as regard to those special regimes of immunity. On the other hand, the ILC has decided to make such classification within the topic immunity of state officials, notwithstanding the final format of the draft articles. Again, this should assist states and other actors in dealing with issues related to immunity and provide better understanding of such issues, which hopefully will limit the divergence of state practice and in jurisprudence. The Special Rapporteur, Professor Concepcion Escobar Hernandez, has proposed definitions of the two types of immunity that are still pending in the drafting committee of the ILC. Draft Article 2, it is stated that immunity ratione personae is defined as the immunity from foreign criminal jurisdiction that is enjoyed by certain state officials by virtue of their status in their state of nationality, which directly and automatically assign them the function of representing the state in international relations. While immunity ratione personae is defined as the immunity from foreign criminal jurisdiction that is enjoyed by state officials on the basis of acts which they perform in the discharge of their mandate and which can be described as official acts. As mentioned earlier, the subjective scope of immunity ratione personae has been debatable in jurisprudence and literature, especially regarding the representation of states in international relations. In light of the arrest warrant judgment, the fact that the heads of states, heads of government, and foreign ministers are recognized under international law as representing states in international relations, including the rules of the Vienna Convention, the ILC provisionally adopted Article 3, which included the Troika in the subjective scope. Article 4, also provisionally adopted, identifies the material and temporal scopes of immunity ratione personae. The former, the material scope, includes acts performed in the former includes acts performed in private capacity as well as acts, official acts, or acts in official capacity. This is the ratione personae immunity. Acts in a private capacity are not defined by, but are to be understood as entailing all acts not performed in an official capacity, that is, acts not in the exercise of state authorities, which I will come to later. Such a contrario interpretation may be necessary to avoid any legal gaps which may arise by having two separate abstract definitions for acts in a private capacity and acts in an official capacity. Again, what's considered as public or private act should be decided on a case-by-case basis and in light of the circumstances. The temporal scope of immunity ratione personae is confined to the term of office of the official, meaning that a foreign state may not exercise jurisdiction while the senior official of the Troika is in office, even for acts committed prior to assuming office. The reason for the temporal application, as mentioned earlier, is to allow the senior official to perform the functions of his or her state, which may be hindered by the exercise of criminal jurisdiction by the foreign state. If this exercise does not entail coercive measures or measures of state authority, then such exercise is not deemed a violation of such immunity. I think Professor Webb will tackle the issue of immunities under the two Vienna Conventions tomorrow in detail. But in relation to the issue of immunity ratione personae, the Vienna Convention on Diplomatic Relations provide in Article 31.1 that a diplomatic agent shall enjoy immunity from criminal jurisdiction of the receiving state. They also shall not be obliged to give evidence as witness, nor would they be subject to measures of execution. Here, I'm not going to go into details, but these are part, whether measures of execution or to provide witness, the ILC, and also with regard to inviolability. The discourse now is to consider them as part of the criminal jurisdiction as such. The convention did not distinguish between private acts and public acts in terms of the material scope of immunity. Article 39.2 provides for the temporal scope of such immunity, ratione personae, by stating that immunities shall normally cease at the moment they leave the country or on the expiry of a reasonable period in which to do so. As in Article 4 and 5, paragraph 3 of the ILC draft articles, immunity ratione materia from foreign criminal jurisdiction for official acts continues to subsist for persons enjoying immunity ratione personae, that is diplomatic agents and members of the administrative staff of the mission, even after they leave the country. A similar provision is found under the Vienna Convention on Consular Relations in Article 53, although the scope of personal immunity of consular officers from criminal jurisdiction of the receiving state is limited. Despite certain views to the contrary, immunity ratione personae remains absolute in international law, in the sense that no limitations or exceptions exist as regard to commission of the most serious crimes of concern to the international community. This is the view of the ILC under the draft articles, which reflects the jurisprudence of the ICJ and customary international law. Immunity ratione materiae is more complex, and it entails determinations on which acts are carried out in an official capacity and whether there are exceptions or limitations to the scope of such immunity, especially for the most serious international crimes. The issue also involves doctrinal aspects, including the attribution of the act that is subject to the criminal jurisdiction, whether immunity ratione materia is state immunity, and who are the officials covered within the scope of immunity. Also, the harmonious application of the principles of sovereign equality, individual criminal responsibility, and the right to exercise lawful jurisdiction as well as the procedures associated with the implementation of immunity ratione material regime, are some of the complex questions that the Commission and the international community in general have been trying to answer. I would like to start by expressing my personal views on the matter before explaining about the approach the ILC took in light of the practice and evolving trends in international law and international relations. Protecting human rights is not peripheral to sovereign equality, nor is justice incompatible with the respect of obligations arising from international law. Such principles act in tandem, are not and should not be mutually exclusive. They complement each other and should always be applied and interpreted to give them full effect and to the utmost extent possible. Accountability is not and should not be regarded as a mechanism to disturb peace, interfere with internal affairs of states, or as a transgression on the sovereignty of states. This should be the goal, to balance, to have a balance between the various legitimate interests involved. A state has the right to protect its sovereignty. It is a legitimate legal interest, but this goes both ways. State has the right to exercise its own jurisdiction, including criminal jurisdiction, but within the limits of international law. Similarly, a state should not be subject to the jurisdiction of another state, which also stems from sovereign equality. On the other hand, international law does not provide the state with a blanket check to block the lawful exercise of jurisdiction by another state. Criminalizing the official is not criminalizing the state. International law has departed from this proposition and created a distinction between the criminal responsibility of the official and the responsibility of the state, which it may or may not incur as a result from the acts by its official. Its responsibility, if the responsibility of the state is the same as the responsibility of the official under international law, then we would not have had international criminal courts and tribunals. As the International Military Tribunal of Nuremberg stated, crimes against international law are committed by men, not by abstract entity, and only punishing individuals who commit such crimes can the provisions of international law be enforced. State or sovereign immunity are in the same vein is not the same as the immunity of state official from foreign criminal jurisdiction, including immunity ratione materia. The ICJ, in at least two cases involving the criminal responsibility and immunity of officials for official acts, could have settled the issue and declared that only state immunity exists under international law with no nuances. It did not do so. In fact, the 2012 ICJ judgment in the jurisdictional immunities of the state case made it clear that such distinction exists between the two forms of immunity. The court explained that, and was referring to the Pinochet case, Pinochet concerned the immunity of a former head of state from the criminal jurisdiction of another state, not the immunity of the state itself in proceedings designed to establish its liability to damages. So the distinction has been made very clear. My final general personal remark on the matter is dual attribution of an act is possible under international law. I'll come to this later in more detail. A state may or may not incur responsibility, but an act that its official carried or performed in an act of a state may or may not incur international responsibility by an act that its official carried or performed in an official capacity or on its behalf. So conceptually, you can have two responsibilities based on one single act. As in the case with immunity ratione personae, the Commission decided to tackle the scope of immunity ratione materia from three dimensions: the subjective scope, who benefits from the immunity; the material scope, which acts performed by the official that are covered by the immunity; and the temporal scope of immunity. Concerning the subjective scope, in her report, the Special Rapporteur endeavored to distinguish for the purpose of its application between senior officials and low-ranking officials, as well as a distinction from between government officials and individuals who do not hold a formal governmental position. The Commission eventually decided to opt for a generic conceptual scope, that is, any individual who represents the state or who exercises state functions. That was in draft Article 2E. The practical implication is that the determining factor is not the nature of the position of the official, but whether the individual performs state functions or elements of governmental authority. Such a connection must be direct between the individual and the state. There remains, in my view, a gray area concerning de facto officials and or those who are outside the state structure, yet connected to the state through the performance of official functions. And in my view, the issue of contractors is yet to be resolved. The issue of material scope of immunity is the most debatable aspect. That is, which acts are considered performed in an official capacity and how to distinguish them from other acts. Practice and jurisprudence have used different terms to describe such acts: official acts, public acts, acts in the name representation of the state, acts of the state, governmental acts, and other terms. This adds to confusion on the matter. Nevertheless, the Commission opted for the term act performed in an official capacity as a more general term that has been quoted several times by the ICJ and other tribunals. I would like to note here that acts in an official capacity or official acts are not actia iuri imperi, which are acts of the state and fall within the context of state immunity in civil proceedings, as has been clarified by the ICJ in the jurisdictional immunities of state judgment. Article 2F, provisionally adopted by the Commission, defines acts in an official capacities as acts performed in the exercise of state authority, whether such authority is legislative, executive, or judicial. The act, therefore, has to be linked or attributed to the state. On this point, it should be mentioned that there has been a conceptual debate whether the act in question can be attributed to the state, to the official, or to both. The Commission recognized in the commentary to the draft articles that dual attribution for a single act is possible and may entail separate legal responsibilities. That is, individual responsibility of the official and the international responsibility of the state. The Commission did not consider it appropriate to define the elements or describe the elements of attribution of the act to the state or to the official, leaving it to the general rules of international law to determine the matter. In any case, if the act is not attributed to the state of the official, then it does not fall within the regime of immunity ratione materia. And I think there's a role in jurisprudence in the future based on whatever comes out from the draft articles on interpreting the issue of dual attribution, which is a very important issue. On the temporal scope, unlike immunity ratione personae, which is related to the term of office of the official, immunity ratione materiae is related to the act itself. Therefore, its regime continues to apply as long as the act is carried out in an official capacity. That is, it is attributed to the state. As such, Article 6 of the draft articles provides that immunity ratione materiae continues to subsist after the individuals concerned have ceased to be state officials. Both Vienna Conventions contain comparable provisions to the material and temporal scopes of immunity ratione materia. For example, while extending full immunity from criminal jurisdiction for members of the administrative staff, Article 37 of the Vienna Convention on Diplomatic Relations provides that immunity from civil and administrative jurisdiction shall not extend to acts performed outside the course of their duties. On the other hand, service staff also enjoy immunity from the criminal jurisdiction of the receiving state in respect to acts performed in the course of their official duties. The Vienna Convention on Consular Relations in Article 43 says the consular officers and consular employees shall not be amenable to the jurisdiction of judicial and administrative authorities of the receiving state in respect to acts performed in the exercise of their consular functions. The two conventions also contain a temporal scope for immunity ratione materia. Under Article 39.2 of the 1961 Convention, for acts performed by persons enjoying privileges and immunities in the exercise of their functions, immunities shall continue to subsist after leaving the country. Similarly, Article 53.4 of the Vienna Convention on Consular Relations stipulates that with respect to acts performed by consular officer and or consular employee in the exercise of their functions, immunity from criminal jurisdiction of the receiving state shall continue to subsist without limitation of time. Nevertheless, diplomatic practice is not uniform on what is regarded as acts in the performance of duties that fall within the scope of such functional immunity. It is doubtful that such divergent practice will assist in better understanding on how to implement the content and scope of immunity ratione materia from foreign criminal jurisdiction under the general rules of the ILC draft articles. I'll now deal with the exceptions or limitations to immunity ratione materia. This is the core of the contention as regards to immunity ratione materia. Is there any limitations or exceptions for acts performed in official capacity? Are such acts considered state functions, or are they private acts? These are some questions that the ILC have been working to providing answers to. It remains divisive within the Commission, which voted to adopt draft Article 7 on the non-applicability of immunity ratione materia for certain international crimes. And debate in the 6th Committee has reflected the tension risen by virtue of adoption of Article 7. I was one of those who voted in favor of adoption of the article. While the scope of crimes included in the original proposal of the Special Rapporteur was wider, encompassing territorial tort and corruption, the Commission decided to confine the scope of grave international crimes, to grave international crimes, genocide, crimes against humanity, war crimes, crime of apartheid, torture, and enforced disappearance. There doesn't seem to be a unified standard that the ILC applied to include such crimes on the list. Crime of aggression, for example, was excluded, although it's one of the most serious crimes of concern to the international community. And it was within the list of, it is part of the mandate of the ICC, while on the other hand, crimes of apartheid, torture, and forced disappearance, which are not independent crimes under the jurisdiction of the ICC, were included in draft Article 7. The Commission avoided making a pronouncement on whether such crimes are within the scope of state functions by using the description, I quote, immunity does not apply. It also avoids a determination on whether such crimes are limitations or exceptions. The commentary to draft Article 7 mentions that there is discernible trend towards limiting the applicability of immunity ratione materiae as regards to crimes under international law. Nevertheless, the issue is not settled. International and national courts and tribunals are divided on the matter. The ICJ, in the context of state jurisdictional immunity, not immunity of state officials, considered that such crimes against jus cogens are not an exception or limitation to sovereign immunity. On the other hand, it provided in the arrest warrant case that a state may try a former foreign minister in respect to acts committed during their term of office in a private capacity without making a determination on the applicability for official acts, applicability of immunity for official acts. The court also explained that it is unable to deduce that there exists under customary international law any form of exception to rules according immunity for an incumbent foreign minister for war crimes and crimes against humanity. And this is the reference in the court's decision, which was subject to extensive debate within academia as well as among countries. Whether Article 7 includes elements of codification or exclusively progressive development of international law also is not settled. Most members of the Commission supported the draft article without emphasizing that there should be judicial and procedural guarantees against political persecutions and abuse. While it's not easy to try foreign officials in national courts for certain grave crimes such as genocide and crimes against humanity, this is not the case for other crimes on the list, such as torture. In my view, the acceptability of draft Article 7 in the General Assembly and by states is dependent on the provision of such procedural guarantees. This brings me to the procedural aspects of immunity, which the ILC is still debating and hopefully will be able to propose procedures associated with the implementation of immunity regime under draft articles next year. I will not prejudge the outcome, but would like to make few comments on the matter. The Special Rapporteur proposed a set of draft articles on procedural provisions in the 7th report on immunities. Such procedures cover consideration of the consideration of immunity by the forum, invocation, waiver, notification, exchange of information, consultations, and human rights and trial guarantees. The Special Rapporteur also proposed in the 8th report dispute settlement mechanism, which may be crucial actually in case the draft articles are to be adopted as a convention or a treaty in the future. This will ease the tensions that may arise, especially as regards to the non-applicability of immunity ratione materiae. In any case, any procedural aspect should, in my view, preserve the balance between the rights of the forum state to the lawful exercise of jurisdiction and the right of the state of the official to implement immunity of its official if it is warranted. 2, that such procedures do not nullify the essence of immunity. This is what the ICJ has said in the immunity from legal process of Special Rapporteur of the Commission of Human Rights. And 3, that procedural aspects should provide guarantees against sham or politically motivated prosecutions of foreign officials. I would like to note that both Vienna Conventions contain limited provisions in this respect. Article 32 of the 1961 Vienna Convention and Article 45 of the Council Convention stipulate that waiver of immunity of the sending state must be explicit or express. Article 42 of the Vienna Convention on Consular Relations also contains an obligation of notification on the receiving state in case of arrest or prosecution of a consular staff member of the mission. In conclusion, I would like to express my sincere gratitude to the Center of International Law for inviting me to speak on this important and multifaceted topic of international law. I apologize for the length of my statement. It took nearly 45 minutes, I also, apologize if I didn't tackle all the aspects of this extensive topic, but I'm happy to answer any question you may have. Thank you, Nilufer. Thank you, Patricia.
Thank you, Ambassador. I think you did a remarkable, very thorough, clear explanation of a very complex area. And so, in fact, 45 minutes certainly is not enough time, but I think you did brilliantly well. The work of the commission, I have to say, for Patricia and I, it was our first year when this matter of Article 7 and the voting, and it was really, for me, one of the most fascinating, stimulating discussions that continues on immunities. And I think you've really laid out the issues, particularly on functional immunity. I think, and of course, the immunity rationale personae is much clearer, although you didn't mention, and I don't know if we have questions, the very interesting case that you were directly involved in concerning the al-Bashir case in front of the ICC. So perhaps you may have an opportunity to make some comments on that and the somewhat controversial finding of the ICC appellate on appeal on customary international law. But let me see if we have any questions. I think I want to first encourage our participants to ask some questions on this. It is complicated, but it's really so important as well in international relations. Lucas, do you have your hand up? Okay, very good. Please.
Well, first of all, I would like to thank you very much for the lecture. I appreciate it very much. There are two questions that I would like to ask about the topic. So the first of all is about the purpose of immunities, because when I was studying the topic, there was this one lecturer, Michaela Frulli, who expressed a view that I have never heard from someone else, and perhaps I would like you to say something about this. Was that she mentioned that there was no distinction between functional immunities and ragione personae and ragione materiae in terms of the reason why it exists. In her view, the case law indicates that there is only one purpose, which is the functional necessity. So they do not differ drastically in terms of the purpose of existence. So this is my first question. And should I proceed to the second, or would you like to answer first?
No, please go ahead with the second. Yeah.
Okay. So the second question is about draft Article 7. I am particularly interested in this draft article. I have studied the first 5 reports to understand what is the goal of the International Law Commission in these draft articles. I apparently didn't understand if it's going to be a treaty or a progressive development, or if it's lex lata, lex ferenda. This is very unclear to me. And draft Article 7 was very criticized, especially by Sean Murphy, who said that there is no practice in this regard. And there was this symposium. I failed to remember where it was published, but 4 out of 5 authors mentioned that there is no state practice. They mentioned that provisionally adopting by vote and not by consensus is not the general practice of the International Law Commission, and that this was an exception. And I would like to know if there are any perhaps any insider views on this matter, because there are some implications, in my opinion, to provisionally adopt a draft Article 7 specifically, without expressing if this constitutes lex lata or lex ferenda. And this may even cause some confusion to national judges, as they do not know whether this is something that should be applied right now, or if this is something that should be applied in the future if states recognize it as a law as it exists. So this would be my two questions. Thank you very much.
If Professor allows me to answer on this matter.
Please do. Yes. I'm awaiting your answer.
Thank you, and thank you, Mr. Fontura, for your questions. They're very pertinent, and obviously you've been following on the work of the Commission and how the ILC draft articles are being, at least the ones which are provisionally adopted are viewed. I agree, and I think I tried to explain at the beginning. The purpose, it's a functional necessity, and that's why I said, the idea basically, as long as you don't hinder the functions of the official or state functions, you should be fine in exercising jurisdiction. It's when you impose an act of authority over the official that it becomes problematic, and then immunity kicks in. The distinction, the ILC, it followed the ICJ in this regard when you're talking about incumbent foreign minister. The IDI said, for instance, that only heads of state and heads of government have immunity ratione personae, and this is by virtue of or the purpose is not clear why you have representation of the state. The joint opinion was talking about the head of state personifying the state, which I think is a very personal view. I'm not to criticize Judge Higgins or Judge Coleman's or Bergenthal, who was my professor, but I think that's an ancient concept, personifying the state as such and mixing between state immunity and immunity of the official. So I think eventually it's one. It is to allow the individual, the official, to perform the functions of the state. And that's it. That's the key test. I hope I was a little bit more clear on this. With regard to draft Article 7, yes, you're right. There is the debate about it and whether it's lex lata and lex ferenda. I've been discussing it for a long time. The ILC does not usually, and I say usually, make a distinction and say, well, this is lex lata and lex ferenda, because there's aspects of any rule which are lex lata and lex ferenda. Unless, even the ICJ or any, other courts where they identify a rule of customary international law in one, case, and then, there's a different wording in another case on the same rule. So you cannot say basically it's all, the content is the same, but the description can differ. So basically you cannot just say, well, these words or this part of the article or the provision is lex lata and this is lex ferenda. We can sometimes do that, but it's not always the case. Yes, there is, I can say that part of it is progressive development, Article 7, and that's why I mentioned that the logic behind containing all the elements of international rights wasn't the same, and it wasn't consistent. The idea basically is to follow what we see as developments, to create a balance, because you cannot just shut the door and say, well, I commit a crime as an agent of the state and I'm immune forever, because it is a grave crime and there's an interest for the international community. You have to balance these interests. Again, these are draft articles. If they become a convention, this is, then you have a bit different basis of a contractual relation that gives effect to these obligations, including the obligation not to claim immunity or against the foreign state in such a situation. But it's not simple, and there is it can be dangerous if it was applied without proper procedural guarantees. Vote? No, we don't usually vote. I remember I had a colleague, he's now retired. He loved to vote in the past, but the vote wasn't in the plenary. It was in the drafting committee. So we vote. We do vote. We don't usually vote, but if you have consensus all the time on the content of the rule, we don't have international. You don't need international lawyers. So it's there's different views on the matter. To say that it's not law, no, that's extreme, because there's extremes. There's saying some who are saying, well, it's lex data, or it should be the law, and some who are saying, no, there's no law whatsoever, no progress at all. I think that's a little bit of the extreme side.
Yes, thank you. And thank you for that excellent, your two questions. And it is very encouraging to know that we have close following, and that you have actually, read all the reports and you hit the issues that are really key and are debated. And of course, Sean Murphy has a very clear view on that, but we have different views, obviously. But I have to say that in terms of Ambassador Hmoud, your point, and then I remember when you made your intervention in plenary, very important about when it's not simply about, sovereign equality, just one side, the balance. And you've made this point, and the issue of impunity. So have we attained that balance by recognizing, the list that we put in draft Article 7? And maybe the other can pose to you and have comments as well. But we can see, and I think this was one of the issues that was debated, it's not absolute. I mean, we see in the Rome Statute, the Convention Against Torture, we know with the Pinochet case, that there are exceptions. Yes. And so I think it's important to highlight that these are not absolute rules, and it's just a question of what's the procedure. So I think, since I don't see any questions, it would be interesting if you could. Oh, you do? Oh, I'm sorry.
Yes, I have a question. No worries at all.
Oh, okay.
Yes, I just wanted to ask Ambassador Hmoud about the al-Bashir case. Do you think it's a missed opportunity that the ILC is not going to address it? Because obviously there is a clash between the enforcement of between the enforcement on behalf of the ICC and foreign immunity before the ICC. So do you think the ILC should have addressed that?
Okay, because I was, I avoided to talk about this issue because I was counsel for Jordan. And if you allow me just to, not to be, because I can't, these are views, I present them as Mahmoud, a member of the International Law Commission, not gonna. Al-Bashir, and I'm not being critical of the ICC as such, but there is a trend in the ICC, and that's unfortunate, is that there's advocacy from the bench. And it's unfortunate. This is my personal view. It's not only the views of Jordan. Jordan has, we were happy as a country that referral to the Security Council and Assembly of State Parties was reversed by the appeals panel. So we achieved what we wanted as Jordan. In terms of the content of the decision, I think there is many loopholes in it. You can speak for a long time about it, but you cannot say a state is an agent of the ICC in performing its functions and jurisdiction. That's a fallacy on international law. It doesn't exist. This is what the ICC was saying in the al-Bashir appeals decision. Another thing that the ICC has said is that two states can create an international court. And by that virtue, that court can have jurisdiction on any person. It's an international jurisdiction. Its basis is customary international law. And that's very dangerous because state A and Y can prosecute the official of state X, incumbent head of state, and saying, well, my authority comes from customary international law. So there's big loopholes on this issue to describe. Now we're going to have, the special rapporteur has suggested something. I'm not going to prejudge that. It's a no prejudice clause with regard to the issue of jurisdictions of international tribunals. But again, there is no, the ICJ made it very clear that there is no exceptions to immunity ratione personae whatsoever. And this is the position taken by the ILC. I will answer Professor Oral's question now. Is there a balance under Article 7? If we agree on a procedure, and the procedure has guarantees in this regard, against political prosecutions, then I think there'll be a balance. But if you don't have a procedure, although the subjective element and the procedure are separate, Article 7, but this is very important. If you are telling me that at any time you can prosecute a head of state of another, not head of state, but the official of another country for acts performed in an official capacity and torture, then it's a way to attack that state. It's going to cause tension. But if you're saying, well, that state has the right to invoke legitimate immunity and then stop the procedure or go to a dispute settlement to settle this matter and say whether the official deserves immunity or not, then there'll be a balance. I hope that was a little bit clear on this.
Yes, no, thank you very much. And if we can impose a little bit more on your time, Ambassador, we have another question that I didn't see. So if I could ask Ankit, if you can show yourself. I can't see you. You have a question? Would you like to ask your question to Ambassador Hmoud?
Sorry, yeah, thank you for the talk. I just had one small question. I think probably both of you could address this, but I did read the articles and it says somewhere in the draft, it says that these are just a non-inclusive and non-exhaustive list of articles, which is just to sort of set a base of what is to be included and other aspects can also be included to it, which is to say that other crimes can also be included to the Article 7 list of the immunities. So if you could highlight that, or possibly what other crimes could be included in this, that's all. Thank you very much.
Well, I mean, it's these are the crimes that we included, but whether such crimes are actually what we think is the most serious crimes that should warrant that immunity ratione materia not apply. Obviously, if other courts or tribunals identify certain crimes in the future which become not subject to the application of immunity, that's a different story. But that's what we have. That's what we identified as such. I hope I was clear in my answer.
Thank you. Thank you so much, Ambassador, for really this excellent lecture on a very, very complex issue and also bringing in the work of the Commission, which continues. I think that you have now given our participants here really rich information. And tomorrow we have, of course, our lecture. So this is a very important, valuable contribution to that lecture as well. So I take this opportunity to thank you so much for taking the time to be with us. You're a supporter of the eAcademy. We appreciate that very much. So a virtual applause to you.
Thank you, Professor Abdal, for this, and I commend you and commend Professor Gavvatalis for all their efforts, all your efforts, and this. This is an excellent opportunity, to disseminate international law in Southeast Asia as well as worldwide in a very efficient manner. And I commend you for doing this.
Well, thank you. And it's thanks to wonderful experts as yourself that we're able to fulfill this mission. So thank you so much. And thank you to the participants. See you tomorrow, same time, same place.
Thank you. And I thank all the help that I got from the center in preparing for this. Thank you. I can't count everyone, but thank you all.
Thank you again, Your Excellency, and all the participants for joining us. For those of you who are tuning into this on our Facebook live stream, please look out for our guest lecture again next week. And you'll also be able to find video recordings of CIL's past events, lectures, and seminars on our website, cil.nus.edu.sg. Thank you and goodbye.
Bye-bye.